Greetings, my name is Chris Fortier, and today I'm going to be reprising a presentation that I gave in October 2013 about the federal practice side of administrative law. Just to begin, before I get started, just want to put out a disclaimer that the views that I will be expressing or that I'll be talking about today are mine and mine only. They do not represent the views of my employer, the Social Security Administration, or those of the United States government. So none of the statements I'm going to be making today are official statements and should not be construed as agency position. So let's get started. A little bit about me. I started work with the Social Security Administration in June 2009. I started with the Charlottesville, Virginia hearing office as an attorney advisor, writing legally defensible decisions for administrative law judges and Social Security disability hearings. I moved to the National Hearing Center in Falls Church, Virginia in January 2011, and I do pretty much that job, plus I was also able to review evidence for hearings before the hearing and assist judges with any interesting legal issues that arose during these disability hearings and any other outside issues that came during the process. On the rulemaking side, I've dealt with many rulemakers with a section of Public Utility Communications and Transportation Law in the American Bar Association and with a section of Administrative Law and Regulatory Practice. In those sections, I got to rub shoulders with many attorneys who deal with rulemakings in front of many different agencies. Additionally, I managed to encounter the administrative law process, the rulemaking side on the Virginia State side when creating the social media policy for the Young Lawyers Conference in the summer and fall of 2013. My proposal had to go through all the formal channels and through the Virginia State Bar and was submitted for public comment before receiving ultimate final approval. So I do have a little bit of experience on both sides of the aisle of administrative law. So let's get started. Let's talk about what is administrative law. To put it crudely in one line, it is a body of law that deals with the actions of administrative agencies. Justice Breyer of the U.S. Supreme Court put it a lot more eloquently. Probably a better definition, too. It is legal rules and principles that define the authority and structure of administrative agencies, specify the procedural formalities, determine the validity of agency decisions, and specify the role of the courts and government entities that get to review the appeal of that administrative agency. As you see, that is in his book, Administrative Law and Regulatory Policy from 2001. So you might be asking, what is the basis in the law for this entire area of practice? Well, here are a couple of statutes that you need to know by heart. At least you need to know the name, because many people in the administrative law world refer to these statutes frequently. First one is the Federal Administrative Procedures Act. The citations are noted there, Public Law 79-404 and 5 U.S.C. 500 through 696. These define the roles of an administrative law judge and administrative hearings, in addition to the rulemaking process that I'll be going over a little bit later in this presentation. That law was created in 1946 and was modified in 1980 with the regulatory flexibility. As you see, that's within the APA. 5 U.S.C. 600 through 612 were amended. As you see, that's Public Law 96-354. Two other laws that have significant effects on administrative law, but I'm not going to go over significantly, are the Freedom of Information Act, which, as everyone knows, is the law that defines what documents from government agencies can be disclosed to the public versus those that can be withheld, and the Sunshine Act, which is essentially the FOIA for agency meetings. So what meetings have to be open to the public versus what meetings does the government have an interest in keeping secret? That's seen in 5 U.S.C. 552. Federal agency that you're going to be appearing from has the statutory basis granted by Congress through the APA, as seen here, and in the agency's specific statutory basis, which is found. Usually each agency will have a portion of the United States Code, plus they have a more significant portion of the Code of Federal Regulations that defines what each agency can do in their powers, and that is, of course, granted all through Congress. So let's see, what's affected by administrative law? As you see there, almost everything is affected by administrative law. I mean, take a look at the room around you. You'll see something that's had something done through the administrative law process, like a safety regulation, maybe a pricing regulation. I mean, everybody has electricity plugs in their room, especially if you're viewing this presentation over a computer. Electricity is done through state and federal administrative processes. I mean, you could look at tables, chairs, televisions, your food. So everything has had to go through a regulatory process, whether it be a rule-making process for safety, a rule-making process for pricing, a rule-making process for fresh versus stale. It's all there. As the Honorable Joe Whitley, the chair of the ABA section of Administrative Law and Regulatory Practice in 2013-2014 said, it's everywhere in our lives. I mean, literally, everywhere. He talked about how the process is literally cradle to grave. He talked about how cradles were regulated through the CPSC, Consumer Product Safety Commission. Flammability, those were all done through the rulemaking process. The flammability rules that each crib maker and each component of a crib, they have to go through in order to be put on the market. And yes, the caskets that house our bodies as we get buried also have rules regarding safety that were created through the administrative law process. The caskets that house our bodies as we get buried also have rules regarding safety that were created through the administrative law process. For example, in Virginia, we have the Board of Funeral Directors and Embalmers with their own rulemaking process, literally to the grave. If you're curious about what the rule is on the federal side, the Federal Trade Commission has what's called the funeral rule. Google it to learn more. So he was not kidding when he talked about cradle to grave, and it's everywhere, as I've just shown you. So this does create some opportunities for attorneys looking for work, attorneys looking to expand their careers. Two types of practice that you should be aware of. There's a rulemaking practice and adjudication, agency adjudication. You could also look through the appeals from those administrative processes too, but you're going to be looking at two types of practice primarily when dealing with administrative law. As you know, rulemaking is how an agency makes the laws that the legislature passes work, and I'll go over the formal processes in just a minute. And adjudication, of course, is the way to resolve conflicts with a specific agency, or it may be between two different parties. But because of the type of case, the jurisdiction that the case has, it falls within a particular agency. Two types of publications you want to keep in mind when dealing with administrative law on the federal side. Number one is the Federal Register. Get to know this book well. You can also access regulations online through regulations.gov. That is simply the Federal Register. In a more easy to search form, you can search by agency, you can search by the type of ruling. You can do all sorts of wonderful things on regulations.gov. And the Code of Federal Regulations, the CFR, you will be citing to rules and regulations from the CFR when making your case in front of an agency. That's where all the technical aspects of that agency's practice reside. So get to know these two publications very well. Let's go into a little depth about rulemaking. We have a federal rulemaking process, and you can learn in more detail by Googling Federal Rulemaking Process. The Federal Register has this nice guide to the rulemaking process, all sorts of ways you can make rules. There's a formal process and an informal process. I'm going to go over the informal process as it is more common to see than the formal rulemaking process. Congress passes a law and the president signs it into action. If you want to know more about this first step, I recommend a great video by Schoolhouse Rock called I'm Just a Bill on Capitol Hill. It's a very catchy song and goes over the process very well. So now that we have this law and this agency has been given the authority to enforce this law, they go about, they assign the law to a certain office to enforce, and they start enforcing the law. Well, we go down the road here a little bit and we find that there is a gap in the law, or that there is a problem in enforcing the law. What is that agency to do? They turn to the rulemaking process to fill that gap or to solve the problem in enforcing the law. So we do a few things in the preliminary process, and the purpose of that preliminary process is to shape the rule. Basically, the agency can start this preliminary process by itself, or we can start the process through the old-fashioned petitioning the government method. So anyone can create a petition, and if the agency agrees with the petition, then we get into the preliminary process. Basically, you'll see these as NOPRs, Notice of Public Rulemaking, or NPRM. Sometimes both acronyms are used, but that's the formal title, Advance Notice of Public Rulemaking. Basically, you'll see in the Federal Register, we have this problem. Public suggests some ways for us to enforce this law. The agency gives the public 30, 60, 90, however many days they give, and they evaluate the responses. If they like those responses, then they have an idea. And that idea becomes a proposed rule. Sometimes the preliminary process may get bypassed, and the agency knows how to enforce a rule to solve a certain problem. You see what's called the Notice of Proposed Rulemaking. Here is the rule. Please comment. This is where an agency floats a proposed rule, and the public has however many days they have to respond. You'll see these in the Federal Register too. They have their own section. And after the comment period closes, the agency can do one of two things. The agency could accept the comments and move on to the final rule, or if they do not like what the public said in their comments, they may try to put out another notice of proposed rulemaking just to make sure that they can that they ask the question better. Sometimes that happens. If the agency likes what the public stated in the proposed rule, then they can go and create a final rule. The final rule is what the regulation will ultimately be. This is published in the Federal Register. It is given an effective date, and in the notice, you'll see that it is codified in the Code of Federal Regulations. You'll see exactly where the changes in the CFR are. There are a couple ways that the process can be bypassed. The Administrative Procedure Act allows for what are called interim final rules and direct final rules. And if you want more detail on that, of course, Google Federal Rulemaking Process and reference that document from the Federal Register that I was talking about. And so the rule goes into effect, but as part of checks and balances, Congress and the judiciary can modify the rule or overturn the rule. Congress, they can basically pass a resolution directly to just disapprove of this final rule. And of course, they can conduct hearings, they can restrict funding for a particular purpose, or they may even enact legislation to overturn the rule. So those are what Congress can do. On the judiciary side, we can do review and action. Basically, someone affected sues the agency, so they have to have standing. And the questions that you want to consider are, was the rulemaking procedure proper, as defined in the statutes as we've discussed, or even all the way up to the U.S. Constitution? And does the rule go outside the agency jurisdiction? That's always a good one to consider. And, of course, always, is the final rule capricious or an abuse of the agency's discretion? And the court, as part of its powers, can either vacate part or all of the rule. So I have here an example on this slide that shows you what the Federal Register looks like. I've chosen a final rule from the Social Security Administration that was back in 2010. And a little background on this problem. A child can claim Social Security benefits off of their parents' work record. They can also claim, as an extension, they can claim off of their step-parents' record too. But under the old rule, if the birth parent and the step-parent divorce, the ex-stepchild could still claim off of the ex-step-parent's earnings record for Social Security benefits. If the marriage was divorced or annulled, that was still not, you could still claim off of an ex-step-parent. So we'll go over that a little bit right here. In order to tell if something's a final rule or an advance notice of rule, take a look at number 1 or number 2. Number 1 talks about the action that directly states what's going on. And of course the header, as you see in number 2, that defines exactly what section we're in. So rules and regulations means we're in final rules. Number 3, as you see, is the effective date of September 27, 2010. And we go down to number 4, where we talk about the problem that I just explained to you. In number 5, we talk about Congress. Essentially, Congress passed the contract with America back in 1996, which granted them certain powers, and the House Committee on Ways and Means conducted an investigation and found this problem that I just discussed. And so the Social Security Administration decided to change its rules. Number 6 determines what was the proposed rule. The proposed rule was to basically stop the whole thing of an ex-stepchild taking off of an ex-step-parent's benefits to claim Social Security benefits. And so what happened in number 6 was saying that the Social Security Administration would prevent the claim off of the ex-step-parent in the case of a divorce. Now, as you see in number 7, the Social Security Administration wanted to also apply this new rule to annulments, but ultimately they decided not to adopt this particular rule it's a little bit of a technical reason, but because the agency thought that this problem could be defined elsewhere in the federal regulations, particularly, I believe, as it says here, in parts defining marriage and talking about marriage policy. So we go on to number 8. Number 8 is where we discuss the public comments. The agency received 3 comments, or I believe, yes, they had 3 comments. And as you see in number 8, the public had 60 days to reply to the proposed rule. Number 9 are the comments. 9A and 9B are the comments from the public. And number 10 are number 10A, number 10B, both are the agency's response to those comments, whether they adopt the comment or whether they do not accept the comment and for what reason. Number 11 talks about the procedures that the agency underwent in making this proposed rule change. And in number 12, you see the parts of the CFR that are amended to account for this problem that was initially defined. So that's what a Federal Register looks like. There are some minor differences when you're looking at proposed rules. You're not going to have, of course, the comment and response that you have. You may have a more general question, or here is our rule. Let's put it out for the public to hear. The public has so many days to reply to that rule. Let's talk about adjudication. That's another practice that you can have if you are on the administrative law side. Usually it's a quicker and more efficient way to settle claims and suits against the government or potentially other individuals. Now, the laws that you're going to be using, the processes that you're going to be using, sometimes even the rules of evidence that you may use in the adjudication process, they will vary between agencies. Some agencies like to go all the way to the formal federal rules. Others like to do a very simple process. It just depends on the agency, as each agency is able to define their own adjudicative process as much as they can, but within the parameters of the APA and within the statutory grant from Congress. So be aware of those laws. These are courts of very specific jurisdiction. Don't forget that these are very limited jurisdiction areas. So you're going to generally see claims, enforcement actions from a particular agency, or other very specific topics are going to be going through the ALJ hearing process. Another interesting note, these judges that you're going to be appearing in front of were hired through the OPM process. This is a merit process, not a political process. None of these judges are appointed by the president, and none of these judges are confirmed by Congress. So just a quick example of some of the cases that you're going to be dealing with if you want to be doing administrative law. You're more than likely to be dealing with Social Security disability cases. There are over 1,400 judges in offices in 49 states across the country and Puerto Rico. What is the one state that's missing? That would be Vermont. Some other common types of cases that you're going to be dealing with are veterans' disability cases and Medicare hearings. If you're doing employment law, you're probably going to be coming across the initials NLRB and EEOC at least once in your career. Those stand for National Labor Relations Board and the Equal Employment Opportunity Commission. If you're doing immigration, you're probably going to be coming across this process too. You probably will be dealing with at least once in your career the Department of Justice's Executive Office for Immigration Review. So as you see, plenty of agencies use ALJs. I mean, that is a load of agencies. You are probably familiar with many of them, maybe even just a few of them. But that's not all the agencies in the federal government. For all the agencies that are not listed here, they can use ALJs, they can borrow ALJs, administrative law judges, from any of these other agencies with the permission of the Office of Personnel Management. So let's talk a little bit about the levels of determination that go on in the adjudicative process. You have 4 types: the initial determination or reconsideration, sometimes enforcement actions. You can consider the investigation and the initial decision from the investigation as part of that initial determination. Of course, the administrative law judge hearing, which most of you will probably be familiar with at some level or another. You have administrative appeal, which can be done within the agency, or you may be going outside the agency, just depending on the processes and the rules you're dealing with. And then after you've exhausted all your administrative options, you have the U.S. District Court, the U.S. Court of Appeals, and finally the United States Supreme Court. Let's begin with the initial determination. This is usually done by the agency or whatever group of people who are appointed by the agency to do this particular process. In Social Security and Medicare hearings, your case may be going to somebody who works for the state that your claimant, that your client resides in for this process. In other cases, you may be dealing with an enforcement detective or someone within that particular agency itself. Your client does have a right to be represented at this stage, but there's not going to be a hearing. As I said, this is the initial portion of the case. The adjudication is done by somebody in the agency by itself. And it's just based on the review of the evidence. So essentially what this person is doing is they're taking a look, they gather evidence. You may provide some evidence as you advocate for your client, but there's no hearing. You can file a brief, but that's pretty much the extent of what you can do. Of course, that's depending on your agency's rules. Now the person has made the decision in your case, and you may be able to appeal directly to an administrative law judge hearing. Other agencies may require a second review within the particular framework of that agency. So you may be going back into the initial determination phase, and in some places that's called a reconsideration. You would just be going to a different employee. So now we have probably the most important part, especially for your client's case, that you may be dealing with in the administrative law practice, the administrative law judge hearing. Let's take a look at who is involved. Of course, you have the administrative law judge, and we have your client. Now, Expert witnesses may come in to provide some insight into some technical issues. Your client may have some other witnesses that they may want to have come in and testify, which that's up to you to determine whether it's useful or not. And if you're dealing with with some agencies, the agency may have an attorney themselves come in and represent either the public interest or the agency interest, just depending on your agency's process. And of course, the role of the ALJ may be someone who represents, and they may just be impartial, or they may have to represent the agency's interest depending on if there is an agency attorney there. Usually, if there's not, the ALJ may have to represent the agency's interest in addition to being an impartial arbiter. In some other agency practices, particularly Federal Energy Regulatory Commission, they allow for parties called interveners to come in and be a part of your case, be a part of the process for your case. And so be aware of that. There may be a bunch of other parties that come in. I know the largest number that I've heard people talk about for a FERC hearing, I believe, is 29 parties. 29 parties. Imagine all the fun with 29 people. Definitely something I could not adjudicate by myself. And so there are some differences with a trial that you may commonly know of. You may see some more relaxed rules. Some of the hearings may be more informal because of the number of parties that are involved, or simply the agency's wish to make hearings a simpler process for the people that appear in front of them. It can't be that way for every agency because, particularly if you have a lot of parties, you may have to have a more formal process when dealing with the case. But one thing that's critical, this is your chance, this is your client's chance especially, to get all the facts out in the open. This is their chance to testify. As a matter of fact, you may be dealing with your only chance to get the substantive case made. Definitely treat this hearing like it is that final chance. Maybe you have a chance further up, depending on your agency's rules, and maybe you get a chance to appear in front of somebody again. But treat this hearing like this is your chance to shine. Do that for your clients. Make sure that they shine in front of the administrative law judge, because there may not be that chance again. That's what I mean by getting it all out in the open. The administrative appeal comes after the ALJ has made a decision in your case and you've been notified. You have the chance to enter administrative appeal. You can file with the agency according to their processes, or you may end up getting your case randomly selected for a quality review. Some agencies do review administrative law decisions to make sure that the law was applied properly. So be aware of that and know that possibility exists. So when you're in administrative appeal, think about this. This is what the appellate body wants to know. What mistakes did the ALJ make, and how do those mistakes adversely affect your client? Depending on the agency, of course, but usually there's no hearing, and the review's based on the record, meaning you need to file a brief stating what mistakes did the ALJ make, and how did those mistakes adversely affect your client. Usually the hearing is enclosed with the record, so feel free to reference that in your appeal. The remand, basically the agency can do a few things in the appeal. They can either remand the decision, which means you go back to the administrative law judge for another hearing. They may deny review, which means they uphold the administrative law judge's decision. Or they may overturn the decision, meaning they issue a completely new decision from the administrative law judge's decision. Be aware that some agencies may require alternative dispute resolution methods before going to an administrative law hearing. Other agencies do have alternative dispute resolution staff ready and willing to assist the parties come to a resolution outside of the administrative law process. So be prepared, know your facts, and you may be ending up getting your decision settled through means other than the hearing. Let's talk about some practice tips. For those of you practicing in the Social Security world, you can Google SSA best practices, and there is a guide that the Social Security Administration published that gives representatives and attorneys some best practices. If you're going to be representing your clients in front of that agency, get to know that document well. They have lots of good tips to assist you with your case preparation. And I do quote one of the tips from the Best Practices Guide, and I apply to anybody going into any administrative law processes. I urge everyone to write a brief. Your agency may have special rules for the brief. Get to know those. You should make it in your practice to write a brief. This is your chance to give your theory of the case, point out significant evidence that you believe is in your favor, and put into context any evidence that's against your client. The remainder of these tend to be rather basic, but you see people sometimes mess up on these. Know the law. It is important that if you're going to represent your client in front of a federal agency, or as I would say even with a state agency or a local agency, you should know what you're talking about. You should know what laws you're referencing. And, of course, knowing how federal and state laws interact. I mean, as an example, can a state agency respond to a federal action? Some states may be totally cool, other states not necessarily. They may have their own specialized processes to react to, say, a subpoena from a federal judge or a federal administrative judge. It just depends. So get to know that law, get to know your agency that you're dealing with, and work from there. Know your client. Some people don't do this. Take some time to sit down and talk with your client before the hearing. This can make the hearing go a little bit faster. You know what you're dealing with, and not to mention, you can advise your client of the rights that they have in front of a particular agency. And that means that the administrative law judge does not have to read those rights again, making the hearing go a little bit slower. So definitely know your client, know what their case is, take some time and review the evidence, and write a brief. Know your ALJ's powers. That's defined in the federal APA and the state in the statutory basis found by Congress, the agency's particular statutes, USC and CFR. And know how to ask questions. Yeah, you should know how to ask questions. You should know what person you're dealing with. For example, you shouldn't ask a witness on avionics in an airplane. Basically, avionics are the electronics that are found under the cockpit of an airplane. You cannot ask an avionics expert about the engineering of an airplane seat back in row 15, the exit row. Basically, make sure you know what field you're expert, what they can answer questions on, as opposed to, say, your client or to a witness. And remember that shorter questions equals more predictable answers. If your question's going 5 minutes, you're probably not going to get the answer that you want. So don't forget to know how to ask questions. And yes, you don't want people replying, to your questions. So just make sure you don't have people replying, to your question. Most important. And you may even avoid the embarrassment of the judge asking you to restate your question or stopping you in the middle of a question to go, Be patient. You're going to be dealing with lots of staff. Sometimes you may not deal with the same person twice. Just be patient with the agency and know that some of these processes do take a while. Respect the court. Sounds fundamental. But there have been people who have appeared in front of an administrative law judge and tried to pick fights with others. And no, I'm not talking about the clients, I'm talking about the attorneys. So remember, if you get hot, calm down. Please calm down. And finally, follow the proposed rules and how they develop. If you don't know, it's going to be like the rules change on a dime. But if you follow the proposed rules in the Federal Register as we've discussed here today, you'll be so much ahead. You'll know what's happening, you'll know when things change, you'll know how things change, and you can provide value for your client by saying the law is changing, the regulations are changing by X, Y, or Z. So that's going to be one of the more important things that you'll be doing to help market your practice and just make yourself more competent, as is your ethical duty under Rule 1.1 in Virginia. And so that is all I have for today. I'd like to thank you for taking time and listening to this presentation, and I hope you have a great time with practice. Happy administrative law practicing.